such relationship. Zero. This doesn't exist. As a matter of fact, the word that he used was, it's a lie. Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabe's or the Proctors and the Alberts is a lie. His words. So the DA himself
What's up, people?
Proctor's neutrality at issue, and he did it in the most public way possible, and I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all
What's
done.
up, Paul Cat?
He didn't address the court. He didn't address the Commonwealth. He didn't
Tiki
address.
Chops.
He is the Commonwealth. He didn't address us.
Elizabeth.
Defense. What he did do
Raven.
is he addressed the
Honey Dip. Can y'all hear that?
And that was by design.
Give me the thumbs up if you can hear it.
So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a
Good
quick
morning,
second.
guys.
We have presented the court with photographic evidence, not something that we came up with.
Yes,
Something
you can
they
hear it.
came up
Cool.
with.
Karen Reed trial, guys.
In Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother.
Oh, my bad.
Depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie. It's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together. They're in a wedding together, in the wedding party. There's a third
Hit the
photograph.
thumbs up as you come
When
in.
was that? When was that? When was that?
2012.
All right, turn the trial up.
So this relationship, as the court just noted, and I was about to get to,
It's all the way up.
is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship.
This is the Karen Reed trial.
They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships.
Hey, Grady Bassmaster.
That. Trooper Proctor was seated at the same table having dinner with Colin Albert, Chris Albert.
Good morning, Bonnie.
And Chris Albert's
Joyce.
wife, Julie.
We in court this morning. Karen Reed
Then there's the
appears for
Facebook
motions.
post, and I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date, for more than a decade. They've socialized with him, and his family considers their family to
Is
be
that the
so
turtle
close
riders
and
in the back
interconnected
benches?
that they are deemed
Probably.
a second family.
You notice they're all on the Karen
Who
Reed side.
exactly are members of this Albert family and or McCabe family? Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law.
Good morning.
Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle in the same familial circle, and that is who the Proctors have proclaimed to be their second family. And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject.
The source video is low. I shared the volume.
In this case, and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting? No, he never disclosed it. We found out about this
Thank you, Mama
because
D.
a concerned citizen happened to photograph Jennifer McCabe's car parked outside Michael and Elizabeth Proctor's personal residence in the evening after hours. And the best that counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe. Or maybe not. The suspicious part is Trooper Proctor isn't saying. And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter?
AJB's mama
was home. They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor, the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't
What
talking
does it
about
matter
sports.
if they were
They weren't
best
talking about
friends?
weather. They were meeting about this case.
T
So how
Bell,
does that not
good morning.
show a bias, and how does that not implicate Karen Reed's constitutional rights to this information? And to this day, the Commonwealth has yet to concede what obviously is now sort of front page news, that there is in fact a personal relationship between the Proctors and their second family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession. On October 3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate
I agree
relationship
if you get
would
put
look
away.
like if one existed. What a conflict of interest would look like if one existed. And he said, quote, Michael Proctor
I think so,
has been
Granny.
fully vetted, end quote.
Hey, William.
He said there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said it's not like, quote, these people know each other, end quote. And he went on to say it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote. The Commonwealth said that because these facts would surely illustrate a conflict of interest. They would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications. And that turns
Karen
on the
Reed's
question
done.
of asking, how could Trooper Proctor be expected to adequately and honestly investigate this case as the lead investigator, and also investigate the Albert McCabe involvement in this case, with this history of an interpersonal relationship and allegiance to those very people, the very third-party culprits, the very people who should be suspects in John O'Keefe's murder? And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client,
The volume's really low. That's as loud as I can get it.
and to test that voucher, and that's what we're seeking to
All
do.
right, let me stop sharing it. Let me see this. Share screen. Let me go just window. Can y'all hear that? Give me a thumbs up if you can hear it. Can you hear it now? Give me a thumbs up. No. All right.
Witnesses, including Jennifer McCabe, based on bias, and that is
There you go.
fundamental
As good as
to our
I can
justice
get it.
system. So striking
Turn
this
your stuff up.
balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial.
Can y'all hear it now?
Elizabeth
Okay.
Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly
thank you, guys.
outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
All right, thank you. Mr. Lally, are we going to hear first?
There's
from,
Karen Reed looking evil.
Counsel for Ms. Proctor, counsel for Ms. McCabe. I got an appearance this morning of counsel for the troopers as well. Counsel for the troopers going to address us.
No, Your Honor, that's in
Okay.
reference to another motion.
Okay, so I will hear counsel for Ms. Proctor.
Thank you, Your Honor. Good morning.
Ms.
Good morning.
Proctor's lawyer.
For Elizabeth Proctor.
Good morning, Mr. Cadwell.
So this is not a balancing test between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights. This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17 that is not within the framework of Rule 17. And I'm sure the court has had the opportunity to review our papers. Our sole basis of an objection is not Ms. Proctor's privacy rights. That is obviously a paramount concern to any third party. And the interest in not being harassed or brought into a criminal matter or civil
stalked
matter that individual has no involvement in is obviously of interest to anyone. But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why I assert what I assert in my affidavit.
He missed with his hair.
Essentially conversations with individuals who have personal knowledge of where Michael Proctor was on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these 2 families, and who had personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with 2 children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these 2, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Mr. Proctor's sister has a friend whose sister is married into the Albert family. And that's Chris Albert, not Brian Albert. And so what brought these different families to a wedding in 2012 was the fact that Mr. Proctor's sister, or Elizabeth Proctor's sister-in-law, was getting married, had her friend at her wedding, and her friend's sister and her family also wound up attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think, is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest, are not what that affidavit makes it seem. Regardless of all of that, there's still issues on admissibility and relevance under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe and why that meeting occurred in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms. McCabe in an area that is already potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17. That is a hope, that is a conjecture, and that is not the purpose of the rule. And I'm not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be
Good morning to you.
likely to be admitted at trial. It is not for discovery. It is not for exploration, whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be
this
other
is a
meetings.
Karen Reed motion hearing,
Close
guys.
parentheses, may reveal information necessitating further pretrial motions, including a motion to dismiss based on extraordinary governmental misconduct. And that's the purpose of this Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be admissible under any rule of evidence. And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the rule of Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails. And the fact that they are looking for these records as they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so, based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right. Thank you very much.
His hair is fucked up,
Mr.
but he
Reddington?
did good.
Do you want to add anything? I do have your motion to join in the opposition that was just argued by Mr. Kettlewell, but do you want to add anything to that, sir?
No, Your Honor.
Thank you, Moto Mom.
As I indicated in the motion, is join in on the motion, noting the objection of Jennifer McCabe. obviously asserting her privacy rights.
Thank you,
obviously
Moto.
Suggesting, as counsel just did,
That was awesome.
this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result of their being witnesses on a case and cooperating with the government's prosecution of Ms. Reed. So I suggest to the court that comments like the records may reveal, and they possibly would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And it's so frustrating to the McCabe's and everybody else because they know whose kids these are. The parents know that they're their children, but nevertheless, they consistently suggest that this is showing that he's sitting there with these two kids that are the McCabe's children, and therefore, as counsel argues, this is evidence of extraordinary governmental misconduct, which is a wild accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting. And the fact that the counsel has indicated that the government basically concedes and assents and does not oppose should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court.
They're about to rule against Karen Reed. Watch.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply,
They're gonna.
to the microphone, I would simply note.
They're making shit up. They don't want to hear that
as
conspiracy
to
shit.
My brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point. There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case. Not
This is a Karen Reed motion hearing.
Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limits of taking the witness's word for it. And I would simply bear upon or ask the court to review the actual holding in Abel. Justice Rehnquist does not state that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather the court specifically held that it's permissible to impeach a witness by showing his or her bias. And that's all we're seeking to do. In the court's words, Justice Rehnquist's words, quote, a successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony. And that's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettlewell, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lampron. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything
There
to
you
that?
go. You got to meet that shit in the court of law.
I'm good, thank you.
Let's see what they rule.
All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
Thank you, Your Honor. Not to belabor the point, but just to make the Commonwealth's position clear, the Commonwealth is not opposing. The Commonwealth, however, does not assent, does not concede anything as it relates to any sort of relationship or whatever is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend who has a sister who has a husband who has a brother who has a wife who has a sister who is Jennifer McCabe.
That's a lot.
And it's such a close personal relationship that after apparently scouring social media, there are exactly 0 photos that counsel has produced of Ms. McCabe and Trooper Proctor pictured together at any point in time. And essentially what you have to establish this close personal relationship is a wedding party from a decade ago and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal
Free clubber.
access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right.
Thank you
I'll take
guys for
this
liking the
under advisement.
videos.
Mr.
Please like it
Reddington,
if you
you're
come
free to
in.
leave, but thank you for attending. You're free to stay too, but all right. So now we'll do the motion regarding the Commonwealth's motion for protective order pertaining to the DNA profiles of the investigating law enforcement officers. So I'll hear from the
I
Commonwealth
think there's
first.
3 motions.
Then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
I will be wrong.
Okay. All right. I will hear you, Mr.
Thank you. Thank you for hitting the like, guys.
So, Your Honor, just to clarify on this, just a point I think maybe misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything at this point. The purpose of filing the motion was to try to gain some guidance from the court as to how mechanisms would be concerned with the collection of DNA, the retention of DNA, the destruction of DNA, and the timing in regard to that prior to obtaining either Trooper Proctor or Sergeant Buchanan's consent in relation to the taking of any bugle swab. So how
Thank
it
you,
sort of
Suzanne.
arises is there is DNA reports in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture. One is positively identified as that of the victim, John O'Keefe. 2 others are unknown. There's been rampant sort of speculation, accusations levied against these particular troopers in regard to contaminating evidence or planting evidence and things of that nature. So the exploration of this is sort of caused by that, in the sense of the Commonwealth believes that whatever DNA comes back, it would exclude those 2 troopers as being contributors to the unknown sources of DNA. So what the Commonwealth is seeking, and the reason that the Commonwealth actually filed another motion asking for sort of an expedited response from the defendant, is the hope of the Commonwealth, especially with March 12th jury trial date looming, was my hope was that there would be some sort of agreement that could be come to and a joint proposal to be presented to the court so the court could act on the papers, and this testing could be well underway, if not already completed, by the time that we reached today's court date. That unfortunately was not what happened. So we received the response earlier this week from the defendant. Essentially, most of the proposals that are included within the defendant's opposition are the precise alternative proposals as far as the protocol as the Commonwealth had laid it out. So as far as the defense not wishing for anybody associated with the state lab or state police to be collecting the sample, that's fine. We had proposed Ms. Christina Owens simply because she's a civilian member of the Crime Scene Services section. But if it, as long as it's a certified collector, it doesn't have to be anybody associated with that. The defendant has some issue with the state police crime lab conducting any of the testing, whether that be generating the sample or doing the comparative testing, and seems to be fine with that process proceeding at Bodie and Lorton, Virginia, where some other testing related to this case is already being done. That's fine with the Commonwealth as well. Obviously, that's going to prolong things a little bit, I would submit.
Do we know that?
I mean, what I can say is that our office would certainly be inclined to pay whatever additional fees would be necessary to expedite that testing. But as far as the time frame is concerned, I really can't say exactly how long that's going to transpire for. But as far as it seems to be sort of the main sort of point of contention is the defendant's ability or access to the actual sample. That is something I would object to. As far as, particularly in this case, I don't think there's really going to be any question that the samples or the profile that's generated is the profile of the individual troopers. It's going to be collected by an independent certified collector. It's going to be the DNA profile will be generated at an independent lab. The comparative analysis will be generated at an independent lab, and counsel would certainly have access to those DNA profiles should the defendant wish to compare it to any other types of any other pieces of evidence or any other DNA that either they recovered during their evidence inspection or that was.
I don't think Karen Reed's going to prison, guys.
In regard to their investigation, so the need for the actual sample, I'm not really sure where that comes from, and the suggestion that the Commonwealth would have more access to it than the defendant would. Especially if
she's going to be found guilty
go with the alternative
and get prison time, but she won't do none of it.
The independent generation of the profile and the independent comparative analysis. I really don't see what defendant's access to the samples does or lends to any sort of credulity to the testing.
They have no way to prove if she purposely did it or not.
That the defendant wishes to conduct.
Yeah, Turtle Boy will.
So
he's in jail now. He's doing time.
So as far as that, I think really the only other sort of disparity or sticking point is the retention. The Commonwealth had suggested
I don't know
the trial process, the reason
Midwest
for that versus what the defendant is suggesting as far as the conclusion of the appellate process is obviously the close of the trial process has a much more definitive end frame to it as opposed to the appellate process that could go on for months and years if not after. And given the limited nature for which the Commonwealth is seeking
it was an accident. She did it, but it was an accident.
Analysis. It certainly made more sense to myself and to the Commonwealth as far as setting that time period if the court wishes to alter that to the conclusion of the appellate process. There are other mechanisms I would suggest that the defendants could avail themselves of should they have a need for, again, the profile would exist sort of in perpetuity in their possession, at least until
he has more charges.
And there are obviously far more mechanisms available today than there have been in previous years as to post-conviction discovery and
if you don't know you hit him, she was drunk.
Again, that was the reason for the suggestion for the
still an accident
process. But again, purpose of this motion was to seek the court's guidance as to exactly what the parameters of that collection, retention, destruction, and all of that would be, so that can be presented to the troopers so that they can make an intelligent decision as far as their consent is concerned.
If this were ordered to be done at the state lab, when would the results be in?
That I think, especially given just prior turnaround time in relation to other testing that's been done in this case at the state lab, I would hope that could be completed within 7 weeks, something like that, at the most.
Okay. Do you want me to hear from Ms. Lundgren now or after? I mean, this is your motion. Do you want me to hear from her now?
I think that's fine. As far as
He's already done more time.
Okay.
Gretchen Lundgren, Your Honor.
Good morning.
Good morning, Your Honor. Thank you for hearing from me on behalf of Sergeant Buchanan and Trooper Proctor in a discussion as their privacy interests as it relates to the Commonwealth's motion.
That about
for
killed me.
protective order.
Damn.
The proposed protective order strikes a balance between protecting the sensitive and personal DNA information of two individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. There are areas of significant agreement between the parties here. Both parties are willing to have an independent law enforcement officer obtain the DNA sample. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same reports and underlying data. Once an independent lab develops the DNA profiles, Your Honor, there should be no need for anybody to have access to the sample thereafter.
Beth?
And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lally said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense
hot mic was
would be on
good.
equal footing
Free my
with regard
homie.
to the troopers' DNA evidence. Each party
Nobody
is
said
to
free
argue
Turtle Boy.
the implication of the results at trial as they see fit. As Your Honor can appreciate, my clients are under no obligation whatsoever to provide their DNA in this matter, but they seek to take steps to demonstrate the integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA, how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right. Thank you very much. Mr. Yannetti, it sounds, when I read your opposition, I did not know that there was this much agreement. Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
Your Honor.
What do you disagree with?
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
Okay, but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay, I have a question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mentioned it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right. I don't have that.
Your Honor, it is one of the alternatives that the Commonwealth had. I'm sorry, I can find
Okay,
that.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need to see about expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's I think like a 12 to 14 week turnaround without any sort of expedition. So, you know, expediting, I don't know that necessarily that can be cut in half, but it is something that I think can be turned around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, you know, at the drop of a hat to provide this sample?
$12 for
Right,
coffee.
so go ahead,
Good
Ms.
Lord.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor. And once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, you know, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There's 300 here.
There
Hit
is
the
an opposition,
like.
Your Honor. I mean, I think perhaps
Definitely.
the Commonwealth can speak to it. I think there's also a strategic decision, a case-related decision. Certainly, we agree with the privacy interests that the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from Mr. Lally afterwards. Go ahead. Not now. I'll hear from Ms. Giannetti to finish.
Right. So there is other evidence in this case where comparative testing, DNA testing could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's
Free clubber. Baby gap.
That should be evidence that either side can use for any proper purpose that is case related. So we should not be prohibited from either requesting or doing our own comparative analysis from those DNA profiles.
What are you going to compare?
Case.
What do you want to say, Mr. Lally? We're talking hypotheticals here.
We are.
Right.
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the troopers' DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, you know, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
So they don't want him testing the DNA for other shit, just that taillight lens.
Well,
so that's why I asked you if it's hypothetical. If you have an item that you want to test, I think the Commonwealth has every right to know what that item is.
Okay, our position would be that we should be able to conduct our own investigation in private and reveal the results of those investigations, of that investigation, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve any disputes before this court. But if we come into possession of anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the profile at that point. We can do our own testing and then reveal the results of that testing should we desire to.
All right. Does the Commonwealth want to be heard?
No, Your Honor.
All right.
May we have just a quick second, Your Honor?
Yep.
Yeah. My co-counsel brings up a good point, which is after months and months and months of requesting access to the physical evidence, we finally appeared at the Norfolk County DA's office on December 1st of 2023 with our forensic DNA collection expert, and he did swabbings of multiple pieces of evidence. So we do have those in our possession.
All right. I had no idea what you were talking about when you were saying hypothetically.
Well, there are two separate issues. There are the items that we've swabbed that we should be able to test, and if we have the DNA profiles of these troopers, there should be nothing prohibiting us from testing them. And by the way, the Commonwealth has the ability to do the exact same testing on their own. And then if there's any other evidence, I still maintain that we should be able to do comparative testing on that as well.
All right. Let's get the samples going. Let's do that, and I'll figure out the rest of this. But let's get.
Thank you, good
What
vibes.
do you have in mind for an independent collector?
Your Honor, I don't have anyone specific in mind, but most local police departments have at least someone who is a detective who is a certified collector. I just
Say someone, the defendant, the two of you work out something.
I don't have any issue with working out something with Mr. Lally.
All right, so let's do it today.
That sounds good.
All right, and Ms. Lundgren, you'll make your witnesses available immediately.
Yes, Your Honor, but I just, for sake of clarification, just trying to understand, and as Mr. Lally said, they have not provided their consent yet. They are waiting to hear what the boundaries of the proposed protective order will be.
Ruby girl, 5 memberships.
Knowing and voluntary consent.
Thank you so much.
Okay.
So, I mean, we could certainly potentially do the samples and hold them in abeyance and not release them if the court was willing to have them destroyed should the troopers decide not to provide consent based on the bounds of the protective order. But certainly I think they do need to know what those terms are before moving forward.
All right, I need to look at this. I'll do it as quickly as I can. All right, is that it on this?
yes, Your Honor.
On this
Right.
motion, yes.
All right.
That's the second
So the
motion.
third and the fourth motion are sort of in their own category. So the third motion is, it's interesting in that I received the opposition, or the opposition to motion for protective order was filed before the motion for protective order, as I had it in the docket. Who's arguing this for the defendant?
This is the protective order regarding the letters, Your Honor?
Yes.
I will be arguing.
All right, so what I can say, Ms. Giannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office. So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
Okay, so they're going to do the third and fourth motion at a new date.
That's fine, Your Honor.
All right, and we'll do it as soon as possible. I do not want to change the trial date in this case. This case will go to trial on March 12th.
I'm going to
And
be
the
there for that. March
fourth motion
12th.
Where I said the third and the fourth are sort of in the same.
There's
category.
$5
The
towards my
Thomas motion for records from Boston Magazine that needs to be appropriately served.
My Cash
and
App
have
is
someone
money
here
sign
from Boston
James
Magazine
TV.
if they oppose it.
Yes.
So
We get it
I'd
from
like to
PJ.
do this as soon as possible. And given our trial schedule and the fact that I intend that we try this case in March,
Looks like I'm going
like
up to
everybody
Boston.
served for a hearing here on January 18th at 3 o'clock in the afternoon.
January
Thursday afternoon.
18th. I might pop in for that one. That's this month, right?
So it's
13
just
days?
about 2 weeks. Should give you enough time if you serve these people today to get them here.
Can you do it?
We can do it
Thank
via
you, Sweet
Zoom,
Liv.
where it's
Your Honor,
discrete issues. Yes.
we're in trial on January 18th. It's a short trial. Is there any other day that might work for the court?
I don't see any time that we can.
Is the 16th at all possible?
No.
No, no.
Oh, that's right on the back of the holiday, isn't it?
We're both supposed.
I understand that. No, it's not available. We start a trial Monday.
We're both supposed to be in trial that day.
All right, so you can do it via Zoom, or Mr. Yannetti can do it.
I can certainly do it. There's no chance of the 23rd, Your Honor?
No, there's no chance that week.
Okay.
You
If
there,
I had been
homie?
served, we would have gone forward with that. I'm more concerned about that one, getting that one rolling,
Understood.
than the other one. All right. So January 18th at 3 o'clock.
Clubber is Baby Gap's dog.
All right. Anything else we need to talk about? Doesn't appear to be.
Your Honor, I think it makes sense to raise this one issue, which is today was the filing deadline for all non-evidentiary motions.
Right, and none have been for evidentiary motions. Today was the filing deadline for evidentiary
Okay.
motions to suppress, things like that.
I understand. So the defense will be filing before the end of business today, not evidentiary motions, but non-evidentiary motions one motion to dismiss and one motion for sanctions and also for disqualification of the Norfolk County DA's office from this case. So
All right, so you were not filing motions to suppress.
Correct.
So they're being waived.
correct.
All evidentiary motions are waived.
Correct. Well, yeah, we'll have pretrial motions in limine. I don't know if they would,
Okay, but everything else, so,
but in
okay.
terms of constitutional issues.
So file them by the end of today, and if we can hear them on that date, we'll do that on the 18th.
Right, and that would, depend on Mr. Lally ability to respond, et cetera, which, I understand he may need some time, but they will be filed today.
Okay. All right, thank you all.
Your Honor, there's several I apologize. Your Honor, there's several housekeeping matters I wanted to address with the court. In regards to the motions to dismiss that Mr. Yannetti, my brother, just discussed, we do have a motion to dismiss the indictments in this case, and I wanted to lodge the grand jury minutes with the court. They are very voluminous. I wanted to ask the court's guidance on how you would prefer to receive those.
So when that happens, we typically get them on a flash drive, as well as, Jimmy, how are they filed with you?
Counsel have filed by email.
Thank you, Dumpling.
Grand jury minutes. They can do it by a thumb drive.
All right, so a thumb drive, but get a separate one for
We'll
me.
mail that to you so that you'll have a hard copy, the thumb drive. The other housekeeping issue I wanted to address with the court, Your Honor, is, as you know, the court has ordered the Verizon records relating to Jennifer McCabe, as well as the Google Nest records. We were informed by the clerk's office those were supposed to be produced to the court on December 15th. My understanding is you guys have not received anything, and I wanted to follow up on that because that obviously is evidence that we hope to have in advance of trial.
Bless Mom from Texas just gifted a membership. Awesome. Membership train.
I've never called.
Yeah.
Lisa
So
P
typically
just jumping on the
defense
membership
counsel calls and says
train.
There's a court order. Where are these records?
I emailed the clerk's office, and they said that they haven't received anything yet, and so that's why I wanted.
Right. So call Verizon and call, who's the other record holder?
Google Nest.
Contact the record holder and say there's a court order. Where are these records?
Okay, but
Okay.
you all have not received anything.
I don't know. Jim? Jim,
Yes,
Have-
I'm thinking.
have you received them?
Could counsel come to sidebar?
Okay.
Absolutely.
All right, Karen Reed sitting there looking evil, crazy. She looks crazy to me. I don't care. Peace and Struggle just jumped on the damn gifting train. Moving on the tracks. Moving along the tracks. She got that crazy look in her eyes. I don't know. She just looks crazy to me. Pat just jumped on the gifting train. All aboard. Thank you, Pat. That's nice of you. PJ just gifted a membership. She's on the train with you guys. Oh, crazy ass Karen Reed. I wonder what she's thinking right now. Put in the chat what you think Karen Reed is thinking right now. She's thinking, I wish I could back my way out of here. I need a drink. I'm going to the bar after this. What? She's probably thinking, fuck Turtle Boy. Mama's just jumped on the damn gifting train. Okay. Country Girl had just become a member. Free Clubber has just gifted a membership and jumped on the gifted train. Chugging along, chugging along. Thank you guys. Y'all are absolutely awesome. I really need to go to jail. I'm just trying to think of what she's thinking right now. She's thinking, I wonder what Turtle Boy had on his trays. I hope I don't end up eating trays. T-Bell has just jumped on the gifting train. Welcome aboard, girl. Good to have you. Thank you so much. And if you get a membership, guys, make sure you thank the person that gifted you. Donna Lane has just jumped aboard the gifted train. Thank you, Donna Lane. We're going to take the train down Donna Lane because she just gifted one membership, and that's insane. Okay. I should have been a rapper.
Free Can't Read, free Turtle Boy.
Free Can't Read for they got their Zoom open. They got their Zoom open. Is that Bex? Gifted one membership. Welcome aboard the train. Grab you a nice seat.
That's it.
Window. That's it. That's it.
Just one last thing, just with regard to the motion to dismiss, as far as does the court want the exhibits that were presented to the grand jury in addition to the minutes, or just the minutes?
Yes, I assume where you say it's so voluminous, it's the exhibits as well, Ms. Little?
I can produce.
You have to stand in Massachusetts. Thank
Yes,
you.
I can produce the evidence as well.
Okay. All right. So everything.
And I don't have a problem providing that to the court as well. I don't want to duplicate matters, but
Okay.
if it's easier, I can do it. It's fine.
So those would obviously be provided under seal, Your Honor, with,
Of course, they're grand jury minutes.
correct. With regard, that's with regard.
She
to
wishes
the
she was
motion
eating
to
that blood
dismiss,
pizza right now.
The basis of which is the grand jury presentation. The separate
Is it
motion,
McCarthy or Odell?
both.
Okay.
With regard to the second motion for sanctions, Your Honor, the letters that were the issue of the protective order that the Commonwealth moved for that we've now put off, those will be part of the quote unquote
Just
evidence
gifted
with regard to the
one
motion for sanctions.
membership.
It's our
Come on the
position,
train.
obviously,
Come on the
that
gifting
those
train.
are not
Get you a nice
exempt
seat.
from public disclosure.
I'm
However,
going to keep them exempt until
Thank
we
you so
hear from
much.
the U.S. Attorney's
that's
Office.
why I raised the issue, Your Honor. I just
All right,
wanted
was
to let
that
the
your
court-
suggestion as well, so we could get moving with this motion
Of
to
course.
dismiss?
Of
Okay.
course. Thank
All
you.
right. All right. Thank you.
You love to see all the new members. Regina Smith.
Thank you.
You got a half-ass smile on her face now.
You are muted.
Kaylin just gifted the big 5 boot. Thank you.
You can go ahead, yeah.
Little Shawnee just jumped aboard the train with us. Thank you, guys. All aboard. The gifted train.
Dr. Grider killed his wife in
Darzilla. Bam. Big virtual hugs, all you guys. Come aboard. Come aboard. Okay. So that was it. How did they rule? I don't understand how that court stuff's going down like that. So they're going to give up DNA. It's going to go to an independent laboratory, and they're willing to do this to show that they don't have no DNA on that taillight lens. Okay. That's kind of what I took from that. So the court hearing, these are all just motions. Okay. Before the trial. The trial starts, what did they say, March 18th? Or was it the 12th? Did anybody catch that? My short term is just absolutely gone. I fell asleep last night. Welcome everyone. Trolling, it's been forever, dude. Okay, because I'm going up there for the Karen Reed trial. I might sit in for a few days. It's not too far from me. I checked out the laws in that area, and they seem to fit my lifestyle a little bit. So the 12th, I will go up and sit in on the Karen Reed trial, and I will bring y'all live updates as I'm there. Okay. No rulings. Okay. Well, that absolutely sucks. I guess they're going to do that on the 18th because they're supposed to be back in the court the 18th, right? The two, because they didn't subpoena the U.S. Attorney's Office. Mustang Sally just gifted 1 membership. Thank you, guys. Thank y'all for jumping aboard the gifting train today. It's a whole bunch of y'all on the train chugging along the tracks. Here's my thing. I'm going to tap in on the Karen Reed stuff a little bit real quick. You know, I do believe she hit John O'Keefe. Okay. I do believe that. I don't know if she did it on purpose or she did it on accident. That's really going to be hard to determine because, you know, my argument for this is if she wanted to kill him on purpose, she wouldn't have went back at all. You know, Little Dove just gifted 5 memberships. Thank you, Little Dove. Make sure if you get a membership from somebody, you thank the person that gave it to you. Little Dove just dropped 5. Free Clubber. Clubber Lane. Gifted $1 membership. And, you know, I don't really know too much about these little motions they're going to use in the court. I don't get caught up in these crazy cases. Now, if it was something else in court, I ain't never been charged with murder. So I don't know how that operates. Now, everything else, I kind of know how it operates in court. But when you get up into these big trials where they're going to put you away for the rest of your life, I ain't never been in one of those. Envy gifted 1 membership. Thank you so much. Thank you so much. You guys are awesome. All aboard the train. Get you a nice seat. We're going to be talking about the Karen Reed stuff for a few minutes. So my whole argument is this. If she wanted to kill him, she wouldn't have went back at all. You know, she was trying to do CPR on him. She was trying to save him. I just think she was drunk and mad and backed into him and left. And then when she didn't hear from him, she panicked and she went back. Now, that is a really hard thing to prove. There's no eyewitnesses, nothing like that. So I'm thinking she's going to be found guilty. You know, she don't have a criminal record. She may get some years and them years suspended, or she may get some probation. I just don't see her going to prison. I just really don't. She has that look on her face like she knows she ain't going to prison. And I don't like that. You know, there's just too much to it. Now, if you take the conspiracy stuff out of it, I still don't think it's hard to prove she did it on accident or purpose. They're right. She hit him, you know, but is it an accident or is it on purpose? You got to prove that she did it on purpose. And I think that's a really hard one. You know, if you was just out there saying she accidentally hit him, she was intoxicated and accidentally hit him, that's a way easier sell. Because you just got to prove that, hey, she was intoxicated. This could have been a tragic accident. Now you got to prove a motive to kill John O'Keefe. Okay. And I just don't think that's really there, other than the fact that she sent him some mean messages and the kid said they were fighting. But really, is that motive to kill somebody? I don't know. So I think it's a hard sell for that. Now, the idiot Turtle Boy, that idiot that's sitting in jail right now, heard Trey's this morning. That dude is in more trouble than Karen Reed. Okay. He's in some trouble. He has so many felony charges. I do believe a lot of those will be dropped. Okay. Some, you know, he is going to be found guilty of something. They're not going to let him get away scot-free. In the end, Turtle Boy might go to prison for a couple years. It may be, okay, new month. You can give 10 memberships. Oh, I can. Okay, well, let's give some of them. I'm not on my, I'll do that later because I'm not on my YouTube right now. I'm on StreamYard. I can't give shit on StreamYard. Okay. When you can see me pulling the comments up like that, that means I'm on StreamYard. If I was on YouTube, I could gift them, but I'm not on there right now. I don't have a gifting button. Prison is definitely worse than holding. I don't know. I'd rather take my chances getting shanked and have a little bit of freedom than being locked in a cell. Me, myself. If you was like, hey, you want to go to jail and do 3 months, or you want to go to prison and do 3 months, I'd probably rather do 3 months in prison. Jail is torture. Okay. Jail's just straight. You can't go outside. It's very limited space. You know, everybody that's waiting to go to prison in jail, they're like waiting with their bags packed. Like, I can't wait to go to prison. Jail is horrible. And I guess it depends what jail you're in, you know, but jails around here, you get no freedom. I mean, you in a box. That's it. Tiffany Tab says prison's way better in jail. I mean, you might have more people trying to stab you, rob you, you know, like that in prison. But at least you can walk around and get a job in the prison, go to school in the prison. Shit, some prisons you can get a damn degree in. So you can go to the library. You can't do none of that shit in jail. I prefer neither. That's a good one. I ain't going to none of them. That's right, because I ain't breaking the law. This is the year of Dolly not going to jail. Okay. I didn't go to jail last year. No, I think I did. Did I go to jail? I don't think I did. Did I? Can't remember. I don't think did I taste handcuffs in 2023? I think that was 2022 that I went to jail. I think 2023, I just fought all the legal charges. So 2024, you know, I went undefeated in 2023. So I'm going into 2024 pretty fresh. So, and I'm going to be hitting all these court cases. So I'm going to try to stay completely out of trouble. I don't know why I'm glowing green. Do y'all see that when I move? That's weird. That's kind of trippy. You made it in 2023. Does anybody know why they changed the charges to more? I don't know. I don't know why they upped the charges on her. To be dead honest, I can't remember. One hand does, yeah, the green hand. Yes, glowing green. That's because I have my green screen on, and it must be something going on. My camera's not tracking as fast as it usually does because there's motion blur. But it's kind of cool. It's like I'm having a 60s flashback when I move. All right, we in the Matrix. You are illuminating, Dolly. It's that glow. It's that glow. You can't hide it. You know what I'm saying? When you glow like Dolly, there ain't no hiding it. Okay. He's an alien. I'm a shapeshifter. Okay. I'm a shapeshifter. Get it right. Get it right, people. Dolly got exposed to gamma rays, turning into the Incredible Hulk. All right. No, it's just my green screen. It's just my green screen. Good morning, Bullhorn Betty. Good to see you. What did I miss, you crazy? Karen Reed had a motion trial. She sat in court, looked crazy. You know, she had that same look you be having. I'm just playing. So she was just in there was a motion hearing, something about, you know, the DNA, what they could do. I didn't hear them rule on it though. Which was weird. Is your turtle powers, Dolly? Fat finger issue. Okay, fat finger issue. LOL. Karen looked pretty happy. Yeah, she had a smile on her face, you know, and because she's probably thinking, I'm free and Turtle Boy ain't. I wonder how Turtle Boy feels that the woman he was simping for is walking around free drinking champagne, okay, while he sits in jail and hears the word trays. That must suck, okay? I wonder if Karen Reed wrote Turtle Boy while he was in jail. Sent him an e-card, you know what I'm saying? Anything. So Turtle Boy, let's see, how long has he been in there? About 3 or 4 days. So the crazy thing is it takes the first week, you don't get canteen, okay, when you first get there, because it takes a week to get canteen. So you got to put your order in, and then that following week, they bring it to you. So when you get there, it depending on which day you get there, if you miss canteen, you won't get canteen for a week and a half. So that means he has nothing, right? Even if you send him money and he ordered it, he still don't have it yet, okay? According to my calculations of jail math. He shouldn't have any canteen right now. So that means he's sitting there hungry as hell. And I don't see a whole lot of people sharing with Turtle Boy. I just don't. He don't have that cool instinctual vibe that people are going to vibe to him. This ain't going to happen. So he's sitting in that bitch hungry as a hostage. When I sat in there that first week with no canteen, I about starved literally to death. Okay? No lie. I about starved to death. That first week is hard because you got no canteen. Everybody's eating all kinds of good shit around you. They're making swoles. People looking fat. You just over there getting hungrier and hungrier. So I know how rough that is. That's a bad feeling right there. That is a bad feeling. When you get that canteen money, it's almost like a party. You're like, hell yeah. Right. But there was one good thing I locked up. There was an old preacher man. And he would hook me up with like bags of chips and shit because he knew I ain't had nothing. So he would hook me up. And then of course, after that, Dolly was straight. I had money. But that first week with no canteen is a rough week of your stomach growling like a bitch. I mean, they feed you in jail. They just don't feed you enough to hold you over. You be hungry. And it ain't like, you know how you just so used to be able to go to your fridge and snack, call Uber Eats. There ain't none of that shit in there. You know what I'm saying? You got none of that. There ain't no go to the fridge and grab something to nibble on. You up in there hungry, waiting for that next tray of fucking nasty ass food. That's how hungry you are, right? You're like, the food ain't even that nasty. You're like, then once you get canteen, you won't even try to eat no more of that jail food. You just be like making burritos and shit like I did. He's probably crying like a baby. Well, you can only cry so long, okay? He's probably out of tears. He's probably out of tears at this point, and misery is setting in. Okay, you can believe when Turtle Boy comes out, he's gonna be a different person than he was when he went in. He's gonna fake it for his people, but in the back of his mind, he knows right now he ain't built for that. He ain't built for it. But the bad thing is, it don't matter if you're built for it. You'll become built for it. You don't have any option. You don't have any option. You can sit there in your misery, or you can get with the program. I'm one of those, let's get to the program instantly, because I don't like being miserable. You know what I'm saying? Take me to the back, bitch. Let's do this shit. You know what I'm saying? I'm trying to play some cards. I'm trying to watch TV. You know, I don't, these holding cells and these PC cells and all that. Nah. Hell nah. Put me with the craziest people you got. Let's do it. Let's ride. You know? And if Turtle Boy did that, his time would have been easier on him. It'd have been, or somebody would have killed him up in the jail. One or the other. You take a chance. It's 50-50. See, I look at it like this. This is one thing Dolly's always had good for him in jail. I'm funny. Okay? I'm goofy. I make people laugh. And if you make people laugh, you ain't going to have a problem making friends. Okay? Because everybody likes a person that can make them laugh in jail. Because you're miserable. You're miserable as hell. You start messing with the funny ass person, you got problems. Because that's the person that's going to make everybody in the pod laugh and have a good time. The best time you can have in a bad situation. So I've always fit in really good. People like me because I'm goofy as shit and say something stupid and they like me. So I can fit in with everybody. Crazy gangsters. I listen to Wu-Tang. You know what I'm saying? I had Mace's album back in the day. I slide right on up in there. You know what I'm saying? You put me with the Woods. Hey, man, I used to listen to thrash. Saying DRI. You know what I'm saying? Punk kids. I know all about the punk kids. Mexicans. My kids half beaner. I'm in it. You know what I'm saying? And when the last time I was locked up, I play cards every day with the Mexicans. So I know I could fit in with everybody. It don't matter where you put me, I will survive. And I don't think Turtle Boy has that ability. Okay, he don't have the ability to fit in just with anybody. You know what they tell you though, get in where you fit in. The problem is he's not a criminal and he's in a jail full of criminals. There ain't nowhere to fit in. You know what I'm for? That's why he's PC'd up, crying, sad. He ain't got nobody to hang out with. Like when I was in jail, we hung out in a group like 10 deep. It was everybody from my neighborhood right here in this area. You know, they had their own little pod in the jail and shit. And even though they were my same neighborhood, some of the people I didn't even know. We all live in the same neighborhood. When you get, it's weird. I can tell you this ain't no lie. When you from the area that I live in this area, and you go to the city jail, okay? Everybody in this neighborhood has grew up together, lived around each other just forever. It's like being in a gang when you go to the jail, right? There's a pod for you, right? With your people from your neighborhood. When I went to jail, I live in this certain area, right? In Norfolk. And everybody was waiting for me. Like they knew I went to jail. They knew I was coming there. And they were waiting on me. Right? So when I walked into the pod, they were like, yo, Jimmy, up here. And I was like, okay. Everybody was in there was from my neighborhood. The whole pod. Okay? This is all the people from this area that went to jail and they got up in the jail and they lived together. So they had me a bunk waiting on me. I was like, damn, that's how it works around here. You know what I'm saying? And then you got people scattered through the jail that are from different areas, but the bulk of the people that stay together strong are the people from this area. So they really kind of like run the jail. Okay. And not only that, the deputies in the jail, they grew up here too. So it's like they kind of run the system. It's weird. PJ needs lunch money, Dolly. Glaire's hat so tight he smashed his brain. Retarded. LOL. Okay. Do we say that big R word anymore, Free Clubber? I don't. Do they use that? Is that going to get me canceled? Yeah, he squeezed his brain pretty. What's the word for it that they use today? Challenged. He squeezed his brain. Challenged, I think, is the appropriate thing to say, right? Is that the PC correct 2024 terminology? He squeezed his brain. Challenged. Okay. Redacted. Mentally challenged. Okay. He squeezed his brain. Mentally challenged. Okay. One of those. He's slow. Is that acceptable in 2024? I thought that was 1980s. Oh, he's slow. Don't worry about him. He's slow. I thought that was 80s. And then, no, 80s was the big R in the 90s. Then by the time we got in the 2000s, it became mentally challenged. Okay. Don't you have to have brain to damage it? I mean, that's a possibility. What if his skull, he don't have no brain, but what if his skull is cracked or something? I don't know. He could have a fractured skull. Yes, slow. How about he's just an idiot? That's still 2024. I think we can get away with that one. Okay. I think we can. I think that's acceptable. Let me ask the judges. Did we take idiot? Yeah, we take idiot. Okay. Definitely acceptable. Hey, Dolly, what is going on? Look, guys, I'm going to get ready to get out of here for a few. Grab me some lunch because I didn't, I woke up. I didn't even know what time I was going to wake up. I was just like, boom, I woke up. My internet just happened to be on. And I seen Karen Reed was in court. And I said, all right, let's fire this live up. So I'm still kind of wiping the crust out my eyes, So I'm going to grab me something to snack on. And maybe we'll come back and do a live on a little bit of everything that's going on in true crime. There's new information coming out more on the Savannah Soda. Well, nothing like new, but new on the people involved and some of the stuff with that. The Christopher, Ramon, the dad, stuff like that. But I definitely going out to the Karen Reed stuff. All right. So y'all be prepared for Dolly out that way because I got some people I want to visit too while I'm there. My homie, my old drummer, he's going to get popped up on while I'm in town. And we will be there to cover the Karen Reed trial, to look at the turtle crazies, right? The turtle riders, which, I hate to pick on turtles, right? Because we all just a big turtle family here. But we the turtle gang, we ain't turtle riders. You jump on our back, you got a problem, all right? There's some missing kids they found after years missing. I just heard that. They found a little boy from Virginia too. Sad. I seen this picture of this pretty little boy. I was like, damn. I just glanced at it because I just woke up and I wanted to fire that live up, go over a little bit of this Karen Reed stuff. But yeah, when I come back, we'll talk about the missing little boy they found. Some more on the Savannah Soto, Matthew Guerrera. A little bit on Rex. I want to talk a little bit about Rex. That crazy ass dude and killed all kind of people. I think when it comes out, they're going to find out he killed a ton of people, right? These serial killers, especially when they start killing early, It's hard to kill people and get away with it now. But some of these older serial killers that have been killing for like, 20, 30 years, their time is coming, because technology is so good. So Rex got hemmed up, but we're going to see other serial killers get hemmed up too. The bad thing about it, some people kill so long that they die off. Like the serial killer actually dies. Okay. Like from illness or age or like, so you got to remember, most people don't kill. Most serial killers are usually white males, 35 and up. So you figure you kill for 30 years. Look how old Dennis Rader was when they call it Dennis Rader. You know what I'm saying? So these serial killers will be getting up there in age, and some of them just drop dead before they catch them. So, and they believe that in some cases of serial killers, or they've went to prison for life, right, on something else unrelated, and they never tied them to the murders. So, and we're seeing a lot more people work cold cases. And as more people work these cold cases, we're going to see the arrest of more prolific serial killers, which is because, me, I like seeing them get caught. I like hearing the stories. I don't like the fact that there's damn serial killers out there killing people, but I like to hear what makes them snap. That's my biggest thing on serial killers, because I think everybody starts off normal unless you're just a demon baby, right? So I think you start off blank, like a slate. And as you learn and your life experiences turn you into who you are, maybe a little bit of genetics. But at some point, these people snap. Normal, everyday people lose their shit. Why? Right? And what triggers it? That's what interests me in serial killers. That's it. The moment that they flip. I could care less about crazy people or when they were normal. What interests me is the moment of the change. Like in Hannibal Lecter, we would say the becoming of the dragon. There's a moment. There's a moment in all of them. That is the weird part. And can everybody flip? Does everybody have the capability of becoming a monster? I think you do. I think it's a lot harder to be a good person, right? You have to work to be a good person in this world. I think it's easy to become a monster. That's just the truth. There is one killer who called onto the Howard Stern show. But all these people become these monsters. I don't believe they were born these monsters. I believe society has made people the way they are. Upbringing, lifestyle, different types of pushing religion on the people make people crazy too. Just a bunch of stuff, right? But there's a point in everybody's mind where they fucking snap. And when they execute serial killers, I'm one of the people that think you should be studying serial killers. Because these people all have similar traits. Believe it or not. There's something, I don't know if it's a genetic thing in somebody or what it is. But it's something about crazy that you can see. You can see it. Like evil, you can see evil. I'm a person that believes that there's evil in this world. Evil forces at play. That the devil is just as real as God. Did these people at some point in their life become possessed by some type of fucking demon? What made them the way they are? Maybe we'll go into that one real deep one night. But for right now, I got to go get me some food. I'm hungry. I'm going to get out of here. I will talk to you guys later. Peace. Thank you for all you guys that donated all the memberships today. You guys are absolutely great. Bring it in. Virtual hugs. Turtle Gang. You are the best. Love you. I'll see you in about an hour or so too at tops. Peace.